Mwa miarie? Karibu karibu. Yes, karibu sana mwana. Na mabusia. Na wao mtata. Wao senata wanje ni.
Wale senata wa Matata.
Lakini tunaona ground ni nyinyi. Kama mnafuatilia Jacaranda ukanga analia tu. Anasema Eugene lazima tuongoze mbele.
Lakini sasa unaenda pale chini.
Life and death matter to the parents of those abducted, and the father of Billy Mwangi is right here in court. I don't know whether they have a parent present in court. Okay, the court wants to hear from you. Baba Billy ongea. Court imesema uongee.
A moment to compose yourself, but I will hear from you.
Jaona mtoto wangu alichukuliwa kwa kinyozi Billy Mwangi.
Mzee,
Mimi naitwa Gerard Mwangi Kalicha.
Gerard
Mwangi Kalicha.
Mwangi Kalicha.
Yes.
Na mtoto wako ni?
Mtoto wangu anaitwa Billy Wanyeri Mwangi.
Billy Mwangi ambaye ni fourth petition. Mzee, endelea.
Mtoto wangu alichukuliwa kwa kinyozi on 21st Saturday around saa tisa akigojea anyolewe.
Yes.
There came two cars.
Yes.
One of the cars was Hilda car, white in color, the new model.
Yes.
Registration number KDG 527D.
Yes.
And your honor, that car had surveyed my home neighborhood for three days.
Yes.
The other car was a double cabin pickup, which was behind that Toyota car.
Yes.
When they came to where my son was, they feel the car was ahead. They feel the car immediately left, but four guys, very strong guys, from the double cabin car,
Yes.
popped out of the car, went, mishandled my son, and threw him inside.
Yes.
And he asked them, who are you? Where are you taking me? Wakasema utajulia mbele.
Yes.
Simu ikazimika wakaenda naye. Mpaka saa hii yaona, I have no idea where my son is. I read these orders that he produced in court today. I was coming for him, and I've come from him. My wife has collapsed. She has collapsed so many times.
Yes.
I did not come with her because I cannot be able to handle it. So when I look around the courtyard, I cannot see my son. I thought he is here. Seriously. Who took my son and where is my son? He have taken a lot of medicine for blood pressure. Yeah. I have also developed blood pressure.
Yes.
At a certain point, it doesn't come down. I was even praying God that when I'm coming on the way, nifike, na ni kweli nimefika. But they cannot kill my son. I cannot see guys who look like my son. That is not here. Where is my son, Your Honor?
Bwana Karisha,
Where is my son? Yesterday, where have they taken my son?
nimekusikiza na sasa ningependa kusikia kutoka wakili, lakini kabla uketi, ningependa kukwambia kuwa mahakama itatatua hilo swali ya wapi mtoto wako yuko, nani alimchukua na kwa sababu gani walimchukua.
And that boy is secret, Your Honor. He's a secret boy. Very critical.
You can take a seat.
Thank you.
You are saying?
Yes, my lord. I was saying this is a life and death matter demonstrated by the father of Billy Mwangi, the parents and relatives and friends of these abducted persons, and also many well-wishers do not know, not just about their whereabouts, of whether they are alive
Yes.
or not, and whether they are in good condition if alive, and what is happening to them. A habeas corpus by nature is a very urgent application, and it is surprising that parties would want 7 days. The question is simple. Do you have them? And if so, produce them. And if you don't have them, the answer is simple. And like I said, it is the business of the security agencies, especially the police, to know. Police can never come to say, I don't know. It is their business. We pay them, we the taxpayers. We pay them to know. And this is the age of information. Satellite images, we know they use them. We know there is CCTV. We know there are 1,001 ways of how they get information. This matter has been in the public domain. The matter the court can take judicial notice of. Therefore, even without a court of law, conscientious officers, and especially the IG, who have taken oath of office, would have started their investigations long before your order. Asking for more time is literally wishing the families of these people ill. And you have heard it from Billy's father that the mother has already been collapsing. You have seen the father, and I'm sure it is the same with all the other parents. I'm urging this court to stick to the date that after due consideration, the court gave, which is the 3rd. I'm also an interested party, and I'll have to spend my new year writing my response, if at all I need to respond. This is not a matter that can be postponed, and we want to persuade the court to stick to the task. I'm also urging the court to take judicial notice of the fact that the police
Yes.
have lately, in the last 3 years, demonstrated a lot of impunity, and I gave the case of Mathair. There are many orders that have been issued and have been in the public domain. Don't use tear gas, don't disturb protesters. They are all not obeyed. It is incumbent upon the court, and we appreciate the order this court issued, to remind everybody in this country whether the IG or however mighty a person is, that we are all subject to the Constitution. And that Constitution, it is the people who give every person mandate. And it is the people now asking, where are our children? That question should be answered with urgency. The third is actually far enough because it's not near. The third is very far. These people were picked more than a week ago. By the third, it will almost be 10 days. What more time can we be asking for? I really want to persuade the court before I give floor to my learned colleague and senior that the third we should maintain the date of the third. Let everybody burn the midnight oil. Let us all put ourselves in the shoes of the persons who are missing. And we can all come back to court and canvass all the issues we want. But the first order in a habeas corpus application is to produce the person, to produce the body, alive or dead. So let the 6 people be produced, and then we can have all the time we want to file lengthy affidavits and to have lengthy submissions. I give floor to my colleague.
May it please, my Lord.
Yes.
Habeas corpus is not negotiable. And you have made it very clear. We have heard from an affected Kenyan parent what they are going through as a family.
Yes.
My sister, mother, learned friend, is a fourth interested party. I want to suggest to you, learned counsel, that all the 55 million Kenyans are interested parties in this matter.
Yes.
Our country is at a crossroads. I mean, the court take judicial notice of the fact the chief executive of the country
in particular High Court application number E216 of 2024,
Yes.
which required and also which ordered the respondents to produce the applicants herein before Milimani, the deputy judge for Milimani High Court at 9 a.m. today.
Yes.
And in the morning, my lord, we appeared before your brother,
Yes.
Justice Muteti,
Yes.
and the said orders were extended up to 12 noon today, whereby they were ordered to produce the applicants. So as a matter of taking judicial notice, my lord, it should be noted that the right to habeas corpus is a non-derogable right
Yes.
under Article 25D of the Constitution.
And so that leads me to the question I asked right at the beginning.
Yes,
question
ma'am.
of jurisdiction.
Yes.
Because if the same orders
Yes.
being sought and issued by 2 different
Yes.
high courts,
Yes.
we must have only one system. Now, it is past the time when counsel has to appear before my brother, Lieutenant J. Have you logged in, brother?
My lord, if I may respond to that issue, we only have one High Court of the Republic of Kenya established under Article 165 of the Constitution. What only differs is the registry pursuant to the High Court Organization and Administration Act 2015, which establishes different registries or divisions of this court. So even when my brother made those orders, he was cognizant that there are some substantive orders that were made before you, my lord. And as such, my lord, what we only invite you at this juncture, my lord, is to consider that prayer 1 orders has not been abided by.
I think we are going round in circles.
My lord, in fact, I instruct to assist the
No,
court.
no. We're going round in circles. I've
23
heard-
FD,
I'm sorry.
my lord.
I've heard from issued orders yesterday. So what we need to do today get a very clear direction up until a hearing. We have a gentleman in this court who is not concerned about the minutiae of law, Article 25 or Article this or that. He simply wants to know where he stands. So what we need is the quickest way to that. And the quickest way to that is for me to give you a substitute here. I say that for this reason. What I would not want us to have on Friday this week is the normal responses. The proverbial ostrich in the sand responses. Where a party, a respondent is saying, I don't know, I didn't see, I didn't hear, I did not. I want to give the respondents enough time for them to comprehensively deal with this. I get the feeling, I have a sense that this petition and this application will guide this nation forward in how we deal with this question of what is colloquially being called abductions. 7 days, I'll grant 7 days. We joined up 1 day. We will come back for hearing. My orders will be reiterated. If the 6 gentlemen are found, I am on duty every day. The criminal division is on duty every day. Nothing prevents any of the respondents or any other party from producing them to this high court or any other high court. But I want to be very, very clear. This hearing that we shall have next week will ask some questions and we will need to have some answers received from this court. That is why right at the beginning I did situate this court's jurisdiction as being quasi-inquisitorial. Quasi. It is also the reason in my orders of yesterday I was very clear. State officers have an obligation pursuant to the oath of office, pursuant to the expectations of the Constitution, and also there is a consequence of contempt. This court will not hesitate next week if these persons are not brought before this court or have not already been brought to cite. So there is no need for a contempt of court application. I can do that myself, and I will do it next week. This is a litmus test, Mr. Nyamodi, for your clients. It is. There is no simpler way to do it. It is a litmus test. The people of Kenya have their eyes squarely first, second, third, and ninth response. They will need an answer that is more than the usual. And that is why I am minded and I will be granting the rest of the answer. There's also the question of the fifth responder. The fifth respondent is constrained in the Constitution from issuing direct instructions to the national police. I appreciate that. But there must also be a response from the fifth respondent in terms of their constitutional obligation, in terms of policy. Is there going to be a policy from the Ministry of Interior on how we navigate this border? There's also a question of the National Intelligence Service. All these bodies need to put in considered responses. Perhaps Friday this week is not too long. Mr. Wood, may I have
By orders to the rest,
Yes.
would specifically wish to make an application for the attendance of the first, second, third, fourth, and fifth respondents for purposes of cross-examination. For purposes of cross-examination on the subject matter. That is, my lord, the Inspector General of Police,
Mr. Njiru, you will note,
Yes, my lord.
you will note that in my orders, order number 8
Yes, my lord.
of yesterday, the persons holding the apex offices in the respective constitutional bodies or agencies listed as respondents of interested parties in this matter shall be present in person at the hearing of the application, or shall
I
otherwise
rest
be
my case, my lord.
represented by duly authorized officers of their respective constitutional bodies. The court has made itself clear on that. Let us not
That's okay, my lord.
let us not
That's
let us not go backwards. So tomorrow is a public holiday, but the midnight oil shall nevertheless be burnt. I am minded to say the 6th, Monday 6th.
That would be convenient.
So Monday 6th for
To bring them before this court within 24 hours. That is not the case here. They've been abducted by the state and by state officers. If the state and state officers are not abducted, they have failed to investigate their abduction. So there are two failures. They failed to protect them from the abduction, or they are abducted them. Alternatively, they have failed to investigate the abduction. There's another failure now, my lord. You are directed yesterday. The most creative orders I've ever seen in this court. I've argued habeas corpus before this court. I've never seen more progressive orders than the ones you made yesterday. You ordered that they be produced before the court today by 11 a.m. 11 a.m. has passed, so we are now dealing with a compounded violation. And we are now in the realm of contempt of court. And so, my lord, this is a matter over which the court could sit from day to day. As president, when our learned colleague Milimani disappeared, this court sat from day to day, sometimes twice or thrice the same day. My lord, this is a case where you have 6 citizens disappeared. The 29 others who similarly disappeared, whose disappearance has never been investigated until now. So, my lord, when state officers become that fond of impunity, the court puts its foot down harder. It does not give them space in the nature of the 7 days that my colleagues have requested. My lord, we would have requested you, in fact, to sit even tomorrow and to demand answers why the orders you made yesterday have not been complied with. My lord, in our application, in our submission, it's not even necessary for the state of life for content. There is content in the face of the court order. And so, my lord, the 7 days are inhuman, they are unreasonable, they are unfeeling, it's careless. It's careless to come before the court and tell the court that these 6 who've not been brought before the court either by the Constitution within 24 hours or by today under the court's order should remain in the abductor's hands for another 7 days. So, my lord, we request you to adjourn this matter until tomorrow and to require the state officers to come before the court in person to explain where these are, what they've done to investigate, and when they intend to comply with this court's order. That's our request, my lord, as a Bloggers Association and as a Catholic Society. Thank you, my lord.
Please, my lord,
Yes.
with your kind permission,
yes.
there was a similar matter.
Take one more time.
Just a moment, counsel. It's not so much an application by the respondents. It was something that I offered.
To collapse that issue. They want to collapse the substantive application. that was the application that has been made.
Oh, sorry.
That has been made.
Yes, please proceed. Sorry.
Yes, Your Lordship. What would have been convenient, Your Lordship, was that the respondents would have brought the 2nd to 7th petitioners and duly report to this court that in fact we are in compliance with the orders. The second to seventh petitioners are before you. Hence, let us converse the substantive issues raised in the petition and application. Secondly, Your Lordship, the petition raises substantive constitutional matters that this court ought to first be satisfied that indeed the petitioners have raised a prima facie case as against the respondent. So again, unless the respondents are submitting before this honorable court that as the petitioners we have proved that our case raises substantive issues, then we could accede to the application for that. But more importantly, Your Lordship, let it be not lost that the application raises a cocktail of orders that is not only limited to the issue of habeas corpus. As submitted before you by the parent of the court petitioner, there is an issue of the use of fake registration plates in the conduct of an arrest during this abduction. That is an issue that we want to be prima facie established by this court. Not forgetting, Your Lordship, that under Order 7, you had directed the 8th respondent, that is the NTSA, to produce records of the said number plate so that it may be known by all and sundry who exactly are these people who are arrested or abducted. This is the second 7. Finally, Your Lordship, this application and petition was drafted on the 26th of December. I'd like to disclose that I was at the comfort of my village, hundreds of kilometers away. But exceptional circumstances, extraordinary times, call for extraordinary measures. It is not about our opinion, it is not about our diary, Your Lordship, it is about the substantive issues raised in the petition. Habeas corpus, which is the nature of within 24 hours. So we'll be seeking that you stick to our orders unless and until they are complied. Your Lordship. Yes, Mr. Manuel.
My Lord, on behalf of the first petitioner, yes, my name is Kabata. And I want to re-emphasize what has been said by my colleagues, the petitioner as well as the interested parties. We are living in interesting times. And if the court will take the number of days, yes, that the second to the 7th applicant petitioners have been missing, yes, it will be possible to say today that that is about 9 days. Yes, the uniqueness of today, my Lord, in how we are computing time, is that tomorrow, God willing, if we will all be present here, it will be right to say that they were abducted last year. Yes. The application dispense the present application by my good friend Mr. Gogola will lose the meaning of what the court has just cited. That in the interim, the court sits as an inquisitorial body to seek to find out certain aspects that will be important in the main petition. What the Law Society of Kenya is saying is that if we were to consider certain orders that have to be complied with. And as we close the day today before the new year, and having listened to the plight of Mr. Mwangi's father, we will be filing a contempt of court application against the 9th respondent. But I am corrected that we will be filing by close of business today against the 9th respondent in person, against the 8th respondent in person, against the 3rd respondent in person, against the 4th respondent in person, and against the 5th respondent in person. The 7 days being requested are completely unreasonable. With each passing day, Your Lordship, the lives of the 2nd to 7th applicant petitioners continue to be at stake. And if, my Lord, you look at the constitutional placing of the prayers that we are seeking in the interim as a law society, yes, they are placed in a constitutional importance just before the right to life. This very court, Your Lordship, this very court, in fact seated in this very room, once arrested the questions that we are talking about on procedures of contempt when 3 innocent missing Kenyans were abducted in the same fashion and in the same style. And curiously, my Lord, because I know the court has this record, is that on the day of sentencing of the acting Inspector General back then, the 3 Kenyans miraculously were found. So I am moving the court that in its own power as an inquisitorial body, that it does not depart from its orders, and that on the 1st and 2nd order, that they be complied forthwith. On the 7th order and the 3rd order, that they also be complied with forthwith, as we shall be in the close of business today filing formally our contempt of court application. We are not satisfied with the responses that the respondents are expressing to court. It is quite unfortunate that their lives are at stake, and as colleagues, we are buying time. That is all. Thank you, sir. Mr. Manu,
Lord, just to make to bring to the knowledge of the court that the 3rd interested party, Mr. Andrew K. Tata, is equally missing. We have been informed that he is within the court presence. They cannot be allowed to participate in this proceedings. Being a party, so we are seeking if directions can be given.
May I say something for the 9th and 10th interested party?
yes, absolutely.
I'll be quite brief about it. My Lord, if the applicants had been arrested by the police for traffic,
What we are dealing with here is a case that touches on the imports of Article 238 on the principles of national security.
Yes.
This matter is so grievous, my Lord, that the National Police Service, who are supposed to appear before you today,
Yes.
have negated and disobeyed your orders. It Article 238, my lords, provides national security is a protection against internal and external threats to Kenya's territorial integrity, sovereignty, and its people.
Yes.
Unless this question is answered, my lord, by these individuals appearing before you, my lord, 7 days will be an negation of the orders. Let them first of all address order number 2, even before they seek to extend time to reply. Why is there Article 25? Article 25 is a facilitative article, facilitating other subsequent articles. Most importantly, Article 26. And that's why you're being told, produce the body live or dead. So, my lords, do not be invited to extend this time for whatsoever purpose. And let's understand, my lords, that Article 238 is paramount in the protection of the rights of an individual and their freedoms and their property, and the peace and the stability and prosperity of the nation. So this is not a case about Billy, it's not a case about Motes, it's a case about all of us. If this court does not bite, tomorrow it's me, Ndegwa, who will be abducted. There will be an application before you seeking to know of where my about. My lords, I rest my case.
And so, Mango, you'll have the last word.
Yes, Your Lordship.
Your Lordship, I'll be very brief.
Of a court order.
Yes.
And council cannot waive the personal appearance of the Inspector General of the Police. It's not too long ago when Inspector Masengeli failed to appear for quite a number of days. We are urging the court to assert its authority
Yes.
for the sake of putting a stamp on upholding the rule of law. Let Inspector Kanja, if that is his rank, I should call him Inspector General so that I do not mistake his rank. Let him appear in person, excuse himself, so that the court may have the discretion to either hear from him or from a third party. If you allow me, and the court has already observed this,
Yes.
that habeas corpus is one writ that protects life and liberty. And when the court orders for the production, the writ is not spent. It is for whoever is holding to come and tell the court, yes, we have the person, or no, we don't have the person, and explain. And we will be able to converse before the court that it is the business of the police to know everything security. So it does not suffice to actually excuse the IG in his absence. We are urging the court that the people entrusted the authority in the court of arbitrating between citizens and those who are wielding power. The Inspector General, on behalf of the police, is wielding powers of arrest, powers of detention, powers of knowing everything security. Let him come and answer the complaints of the citizens filed by the Law Society. Yes, and I will rest the matter there and request that my learned friend and senior in admission, Stephen Kalonzo, add something.
Thank you, Senior Counsel.
My
Senior
Lord,
Counsel, Musyoka.
my Lord, just to add to what Senior Counsel Mathair said, these are matters of great national, I want to add international concern, because matters to do with human rights are universal.
Yes.
So, my Lord, you issued specific orders yesterday.
Yes.
Non-compliance should be met with penal consequences. At a time
Yes.
at a time when the nation is celebrating the end of the year,
Yes.
it is unacceptable that there will be blatant abuse of human rights,
Yes.
and the country is expected just to slide over into the new year. So I urge, my Lord,
Yes.
that penal consequences and accompanied your specific orders yesterday.
Yes.
With the permission of the court, I'll ask Council Ndegwa to conclude that response to what the State Council said.
My Lord, in respect to the joinder of the 9 respondents,
Yes.
he is enjoined in his own capacity. He is not before you to contest his joinder before you. He has not sent counsel to come and contest that joinder in that particular individual capacity. And therefore that question has not been posed, or that challenge has not substantively been posed to the court for determination by the respondent. Additionally, my Lord, looking at Article 245, as read together with Section 8 of the National Police Service Act,
Yes.
the holder of that office is an individual.
Yes.
And Section 8 provides that the service shall be under the overall and independent command of the Inspector General, appointed in accordance to Article 245.
Yes.
My Lord, in the absence of the respondent, all what my Lord can be read into is that he is in contempt of your orders. And for the question of contempt, my Lord, can only be addressed by the contemnor.
Yes.
By the fact that my learned senior Mr. Nyamondi is present, representing the IG, it's prima facie evidence of the knowledge of service of that order on the part of the 9th respondent.
Yes.
And as indicated by my learned senior counsel, and my Lord, I'm informed by the LSK that there is an affidavit of service of record.
Yes. Dated 30th
Dated 30th of
December
December.
2024. I have looked at that affidavit of service. I am satisfied that it complies with Order 5, Rule 22B of the Civil Procedure Rules in terms of electronic service. Yes, Mr. Njiro, anything else to add?
Only to add that, my Lord, that the said respondent be held to be in contempt of the orders. And that we cannot proceed until that contempt is passed by the contemnor. This is a very grievous matter under Article 25.
Yes.
Article 25, as we all know, is a non-derogable article.
Thank you, Counsel. I think you have
Yes, my Lord.
you have not strayed into arguing.
That's correct. Permit me to invite the LSK to
Yes.
express the point.
Yes, Counsel, let me place you on record now.
My name is Kabata.
Yes.
I'm here alongside Mr. Abdullah Mango, Mr. Brian Mandeli, Mr. Manuel, Mr. Brian Karuwa, for the Law Society of Kenya.
Yes.
Sincere apologies that we came in late. We were directed by your brother to appear before him at 12. So we had gone to the other court, court number 4 CM, and we were directed to come.
Mr. Kabata, that is a good jumping off point. There's another High Court matter. I think it is before Justice Muteti.
Yes, it's a miscellaneous.
Yes.
We appeared alongside Senior Counsel Stephen Kalonzo, Mr. Degonju, and other well-wishing colleagues.
Yes.
In the morning.
Yes.
And we highlighted before the court the present petition. What was before your brother is a miscellaneous criminal application, where we took directions that in order for good order, that the two matters be mentioned at 12, inadvertently, your brother had indicated that you are not in chambers and that he will proceed
Yes.
with the application and the current petition before you. And so, with a lot of humility, allow me to call counsel that is instructed by the Law Society in Mango,
Yes.
for purposes of expressing our affidavit of service and also canvassing on the point of contempt.
Mr. Mango?
Yes, good morning, Your Lordship.
Good morning.
Yes, in the matter, Mr. Mango,
Yes.
Your Lordship, we do confirm to have filed a notice of motion application contemporaneously with the petition, both dated 26 December 2024,
Yes.
which you did consider in chambers yesterday on 30th December 2024.
Yes.
A person to your orders and directions, Your Lordship, we did effect service as per our affidavit of service dated 30th December 2024.
Yes.
Wherein I'm the deponent of the same affidavit. Your Lordship, I wish to adopt the submissions by Council Karuwa Jero,
Yes.
by the fact that the ninth respondent has indeed instructed counsel is sufficient to note that service was indeed effected. Your Lordship, I straight go into your order, which is order number 1.
Yes.
That was an order in the nature of habeas corpus. So that Your Lordship, the order that you granted yesterday on 30th December 2024 was mandatory in nature. And it was simple, Your Lordship, that produced the 6 Kenyans, that is Peter Muteti, Bernard Kabul, Milimani, Gideon Tibet,
Yes.
Veronica Plagan, and Steve Kabango. Further to that, Your Lordship, it was expected of the ninth respondent to under oath explain the circumstances of the matter and specifically the whereabouts of the second seventh petition. Your Lordship, this honorable court having been satisfied by service on the respondent, it is only incumbent upon the ninth respondent to be personally present before you today
Yes.
to produce the second seventh petition as instructed under your order 1. Your Lordship, I've also drawn through your order number 5, wherein the court drew to the attention of the respondent one of their constitutional obligations
Yes.
to uphold the rule of law. But more importantly, Your Lordship, you took your time to draw to their attention the penal consequences stated at the head of the court order and the applicable provisions of the law of content of court at the application. That is to say, Your Lordship, that it was incumbent that upon service of the ninth respondent, that 1, he personally appears before you today,
Yes.
and 2, he produces the second to 7th petitioners in court today. Your Lordship, I would humbly wish to disagree with submission by my senior Milimani,
Yes.
and wish to inform court that the issues he raises could be canvassed by the replying affidavit, which leave to be granted, so that we can substantively respond to the issues he raises. But for all intents and purposes, the reason as to why we were in court today was to have the ninth respondent personally appear before you and have second 7 petitioners presented before this honorable court.
Have you been served with the responses, Council Mango?
Your Lordship, I am yet to be served by any responses
including the various notices of appointment. However, Your Lordship, you had given them up to date do the same. I invite everyone to address non-compliance.
Just a moment, Karuwa. Before we go to non-compliance,
Yes, sir.
there's a jurisdictional question that must be answered.
Very well.
There is a miscellaneous criminal application before my brother J. It is coming up at 12 noon. It is not possible for the petitioners to pursue two separate processes. So either this file will go to my brother, or my brother's file will come to myself.
Your Lordship, I'll briefly address, then I'll invite my senior man of address. Your Lordship, I, upon instruction by the Law Society of Kenya, instituted a constitutional petition.
Yes.
Your Lordship, the issues raised in this constitutional petition goes beyond orders in the nature of habeas corpus.
Yes, but you will agree with your senior, Mr. Nyamodi, that by and large, the instant application is in the nature of a miscellaneous criminal application. So you cannot safely canvass that application here, and also before my brother will take it here.
Well, maybe so that we can participate meaningfully in the proceedings before you, and my apologies to court and my
Mr.
learned
Nyamodi, meaningfully participate.
My lord, we have not had the benefit of having sight of the miscellaneous application before your brother will take it here. Perhaps it would be courteous of our colleagues to share it with us, so that when we do put our views on record, it is informed by having sight of the application. Because having taken up the jurisdictional point with counsel for the petition, I think it is only just and proper that we, for the respondents, also put our views on record in respect of that jurisdictional issue. It is not a unilateral issue between the petitioners.
Mr. Witi and Mr. Chochi, I believe Mr. Baraza is in that other matter.
Yes, I know. Thank
Do
you.
you happen to have a copy of the application?
Yes, my lord, you have copies of that application.
Yes. So it was to slide it over to Mr. Nyamodi.
But my lord, the same was acknowledged to move today.
Yes. Mr. Mano?
Lord, with your permission,
Yes.
you asked us a serious question as to what we should do. Now that we have a miscellaneous criminal application before your learned colleague, Honorable Justice Deputy,
Yes.
we appeared in the morning before him, and the indication he gave us was if you're not available, then he will take directions on the two matters. But my lord, if you look at the application that was filed in Kibera, is substantially different. It was not instituted by the Law Society.
Yes.
As a matter of fact, as the Law Society, we want these proceedings to proceed here. The intention was that this is a constitutional petition. We seek that the same be heard and determined before the commission.
Well, the first petitioner applicant is different. What of the other petitioner applicants?
My lord, our proposal would be, considering that the two matters were substantive different in terms of structure, but touching on the same substantive issues, one for production, one for determining the constitutional question, our proposal is that the miscellaneous application before be consolidated with this one. Even in terms of filing, this petition was filed on Friday last week. It came first before the miscellaneous that Malaya colleagues are referring to. We are proposing that the same be consolidated in the order of filing.
I can't give that order myself. You'll appear before my brother Mutesi at noon. We'll make that application before him, and consider and rule on that one. So that is one housekeeping issue. The second is the regional commander. What is his name?
Perhaps maybe an opportunity to comment on this issue.
Yes.
I have had an opportunity to have a look at the miscellaneous application pending for your brother Justice Mutesi.
Yes.
And I wish to state that that is the proper way of commencing should be prosecuted.
Yes.
And my lord, I wish to perhaps just focus a little on the substantive relief that is sought in the petition that is before you.
Yes.
And I want to focus on that relief so that I can make my conclusion.
Mr. Nyamodi, there are some issues that appear to be in the nature of fear, or perhaps you're raising objections to the orders. You can leave that aside. For today's appearance, it's a very simple and straightforward. It's my order number 2.
My lord, you opened the window for the petition, and you have taken submission on jurisdiction from one side.
Yes.
And I just wanted to complete the information in your lordship's mind as you then conclude on the issue of jurisdiction. Because having verbalized,
You conceded earlier that you've not had sight of that application and you're not in that mark.
I have looked at it.
Yes, you've looked at it, Councillor Nyamodi, but you're not in that mark.
But my lord, if I may,
Councillor Nyamodi, let us move to my orders, and that is why we are all here.
most of it.
My lord, may I with your kind permission?
Yes, yes,
My name is Achille Dante.
yes.
I have been instructed by the East African Cartoonist Society and the Bloggers Association of Kenya Bay to seek joinder because this is a matter concerning them. They're concerned about
decided to go to the Hague and file a suit there because of what happened. People just disappearing in the country is something that happens in a country that one can refer to as a banana republic. It's not really what you want. Kenya is a mature country and we continue to be a mature country. Let those who are behind disappearing learn and listen and stop abducting young people and the name of blessing the area life. Thanks very much.
Well, a couple of things. So I think what we want to say is it's a relief for the families who spent the new year who are trusted a bit shy, and that the judicial system should not be used to frustrate cases. But we live in a country governed by the rule of law, and in as much as the 23 plus youthful Kenyans, innocent Kenyans, who are fighting for what is right, not what is easy, because the government has agreed on it. It should be encouraged that this should be the norm each and every day, that frustrated Kenyans are forced to actually fight for the good life of the government and what the government needs by aid and promises. Equally, in as much as they are today, we also call for the production of, and the release of his brother Ronnie, and 4 others, Bernard as well, Peter, all those Kenyans who are abducted, to be released so that they can join their families, because it's quite disheartening that we are trying to roll back, from where we once tried to run away from. So abductions, arbitrary arrest, equally should not be encouraged. So we are happy that they have been released, those who are arrested, and we thank the law surgeon of Kenya for always standing firm, always standing true to its call to protect, safeguard, and defend the rule of law. So with me is the Vice President of the Law Society of Kenya, Mr. Moro Kabata. I would just invite him to say a word to you.
Tumefurahi kama jamii ya mawakili kupata mandugu zetu 23 wamepatiwa uhuru wao mahakamani kwa shutuma za polisi ambazo sio za halali kwetu sisi. Tumezidi kuendeleza ama kuhimiza mahakama kwamba mambo haya ya serikali ambayo sisi hatuambatani nayo ama hatuelewani nayo, ni kwamba wananchi wana haki za kuungana, kuandamana na kufanya maandamano ya amani, na kwamba njia yoyote ambayo si ya kisheria ya kuzuia mbali haki hizi, sisi kama jamii ya mawakili tutasimama kidete, tutahakikisha kwamba sheria ya kikatiba na wala si sheria ya kiimla ndio itakuwa inafuatwa. tumefurahi kwa sababu leo kipindi cha mwisho, siku ya mwisho ya mwaka huu wa 2024 tumepata maelekezo thabiti ya kisheria na ya kikatiba, na kwamba hawa mandugu zetu 23 leo watajumuika na familia zao, watafurahia mwaka mpya wakiwa huru, alafu tutarudi tarehe 21 kuja kufanya ama kuchukua maelekezo mengine kotini. Lakini tunahimiza kwamba kuna utekaji nyara, mfumo wa kuteka nyara wa Kenya ambao unaendelea, mfumo ambao sio wa kisheria bali ni mfumo wa kigaidi. Yani tunasema kwamba kuna watu katika serikali ambao wamechukua sheria mikononi mwao na wanaangamiza misingi ya kikatiba, misingi ya kidemokrasia ambayo sisi kama Wakenya tumepigania muda mrefu. Lakini haimaanishi kwamba tulipopigana tuliweka silaha zetu chini. Silaha bado tuko nazo, silaha za amani, silaha za maridhiano, silaha za kuhakikisha ama kudhibitisha kwamba nchi yetu ya Kenya haitarudi katika mfumo wa kiimla, mfumo wa kibepari. Tunasema kwamba sisi kama mawakili tuko tayari kuanzisha mfumo mpya wa kidemokrasia, wa kisheria, na sisi kiapo chetu kama mawakili, wote hawa walio hapa ni mawakili wanachama wa Law Society of Kenya, tulichukua kiapo kwamba tutachukua sheria, tutalinda sheria, tutalinda katiba na tutafata mfumo ambao ni wa kikatiba. Tumefurahi leo kwa sababu tumeona afueni, koti imeimarisha udhibiti wa sheria kwa kusema kwamba waandamanaji hawa wa amani wapatiwe ruhusa wale watakapolipa bei ya shilingi 1,000 kila mmoja wao, ambao inalipwa sasa hivi. Kwa hivyo muda usio mrefu watatoka wakiwa huru na mnaweza kuwahoji. Lakini nawashukuru wenzangu hapa kwa sababu tumeshinda hapa siku nzima, labda wengine hawaja kula, mimi nilikuwa nimekula. Nataka pia nyinyi wanahabari niwaombee muwe na siku njema, mwaka mpya wa fanaka na baraka. Tutaonana mwakani ukianza. Asanteni sana.
Senator.
Justice has been received in the courts, and we want to say that the courts are the last defense for the people of Kenya. There were no offences committed as such. The affidavit of the police officer did not disclose the offence. But I want to urge young people that the biggest battle is on the courts. We want to urge those who are 18 and have no IDs to get their ID cards. Then go to the constituency IBC office. Is open, is operational, even if there are no commissioners, and register as a voter. That is the best weapon you can have to create change in the country. Without that, we are going to have this problem. Let all the young people be on the deciding table in the next election. We're going to ask the country to have IBC as quickly as possible. We have lost members of parliament, and the places have not been replaced. The abductions are outrageous. We know that state agencies are guilty of this. There's no one else licensed to have handcuffs other than a state officer. There's no one licensed to have a gun, and even nowadays they have guns to shoot the vehicles of those they want to abduct, to follow up, and even vehicles hanging around, tracing people to be abducted. We also want to call upon Kenyans to rein on such people, such abductors, now that the government has denied they belong to them. When you see somebody hanging around as they did in them 2-3 days, number plate with fake numbers, when you search them, they appear to other people. Let the Wananchi also help public arrest on these people so that we can hand over them to the police. And we want the IG to obey court order. Let him come here in court. Either bring these people, he has capacity to arrest these criminals. He knows who these criminals are. Let the IG give orders and arrest the criminals, whether they are they belong to state agents or whether it is even the director of CID or CID officers if they are involved. Therefore, let the rule of law rule this country, and next week we expect the IG in court and we expect the abductees to be released.
Okay, now just a moment for Kia's team.
This is my piece of advice to our President, His Excellency Kenya is our country. We cannot run anywhere. This country needs a lot of wisdom in leading it. does initiative. Another thing, His Excellency, he took an initiative on 11th of July 2024 by dismissing all of the cabinet secretaries. But he forgot only one thing, to dismiss all friends of him surrounding him. All friends of him surrounding him, because they are misleading him, they are not helping him. We want peace in the Republic of Kenya. This is our country. The economic status of our country and the political status, when we look at it now, it's not good actually. Where shall we run to? The image of our country, some years back they were calling Kenya as a country of peace, as a country that most of people really loved it. But at this particular time now, when you look at our country actually, it is in a very dilapidated state. Therefore, at this particular time, I wish also to give my appreciation to the entire court for the arbitration that they did, so that they can be able to release these freedom fighters, mainly to go and celebrate the new year at their home. Otherwise, let me wish you best of luck, the social media for the work that you have done, and may the Lord bless you abundantly. New year of 2025. Thank you very much. Thank you so much.
Power. Power. Forward with the struggle. Forward. Forward. Long live liberation. Long live. Long live. Long live liberation. Long live. Long live.
Oh, amazing. So,
kupitia hapa hivi. Hii wamefunga.
Amen.
When you're ready.
You're ready?